All right, well, thank you and good afternoon, everybody. Thank you for joining us on this webinar. I'll be speaking this afternoon, followed by one of my colleagues, Andrea Thomas. We're both partners in the Employment and Immigration team at HCR. And this is the second in a series of 3 webinars. The first was on Tuesday, and the link to that, if you missed it, will be available today. And the third webinar will be next week. So thank you for joining us. Redundancy clearly is a very current topic, which we'll be looking at in a few minutes. We're broadcasting this remotely for obvious reasons, so I apologise in advance if there are any sound or technical issues, but hopefully not. I will be speaking to you for 10 or 15 minutes or so, and then Andrea will do likewise. And then, of course, we're very happy to take questions. We've already had some, so thank you for that. But if you use the button at the bottom of the screen, then you can submit your questions to us and we'll be happy to answer those. We'll answer as many as we can today, but if we can't answer all of them, then we'll certainly follow that up and get in touch with you. Can I have the first slide, please? Thank you. Now, the first thing I want to say about redundancy is that the key legislation is in the Employment Rights Act of 1996, so some 24 years ago. But you will not be surprised to know that given the current global pandemic, that this is now a fairly fast-moving concept. Only this morning, some of you may have seen on the news that there's been an announcement that the government are today pushing through legislation which will have a bearing on the amount of redundancy payment that employees can claim. The first thing we need to consider then is what is a redundancy, and that fundamental position hasn't changed since 1996. That in order to establish there is a redundancy, an employer must prove one of the following: that there's been a business closure, fairly obviously, if the business closes, that is a redundancy. But it can also be a workplace closure. So if an employer has multiple sites, it may just be that one of the sites or more than one of several sites is closing, and that can amount to a redundancy. Or it can be that the business isn't closing and neither are any of the sites, but there's a diminished requirement of the business for employees to do work of a particular kind. So there's 3 aspects that are relevant in determining what is a redundancy. Next slide, please. Clearly, what employers want to know is when will it be reasonable to dismiss? And the key point is that redundancy is one of the 5 potentially fair reasons for dismissal under the Employment Rights Act. But the employer must always act reasonably, and in relation to redundancy situations, the employer must warn and consult with employees or their representatives about the proposed redundancy. They must adopt a fair basis on which to select for redundancy. And in selecting for redundancy, it's important that you avoid using criteria which might impinge the protection against discrimination on the grounds of protected characteristics. So it's always sensible to adopt a matrix indicating the criteria that are going to be followed, ideally getting employees or union representatives to agree to those criteria, and then applying a fair and appropriate selection process by reference to those criteria. And the final point there is that the employer must always consider suitable alternative employment instead of redundancy. And Andrew will deal with that in more detail in a few minutes. Next slide, please. If there are going to be a series of redundancies, then the collective consultation regulations have to be considered. And it's important to bear in mind that if the proposal is to make 20 or more redundancies within 90 days, then the collective consultation rules will apply. There must be a consultation period in that situation, which must be at least 30 days before the first dismissal takes effect. But if there are 100 or more redundancies, then that consultation period must be at least 45 days. And in the event that employers do not comply with the appropriate consultation requirements, then they may be liable for a protective award, which is a penalty of up to 90 days actual pay per employee. So it can be a very expensive business if you get it wrong. But Andrea, again, is going to deal with that in some more detail. It's important to emphasize that these are minimum requirements. They're not a target. It's not do the consultation within 30 days. It's a minimum of 30 days or a minimum of 45 days. And there's an additional requirement that if the employer proposes to dismiss 100 or more employees within a 90-day period, then you must notify the Secretary of State at least 45 days before the first dismissal. Right? I've mentioned to you that this is the second in a series of 3 webinars. At the webinar on the 4th of August, this will be discussed in more detail. Next slide, please. Whether or not whether the collective consultation requirements are in play, you still have to have individual consultation with the individuals. The purpose of the consultation is to allow the employee to have meaningful input and to make appropriate representations. That can be as to why there shouldn't be redundancies. It could be about the basis for selection. It could be about the application of the matrix and the criteria that have been used, or it can be an opportunity just to generally challenge the decision. It has to be meaningful, so the employer is required to give the employees sufficient detail to enable them to have meaningful input into that consultation. I say that what should be covered, those are the obvious points. Can redundancies be avoided? Can the workforce suggest a strategy to avoid making anybody redundant or reducing the number of redundancies? In terms of the matrix and the criteria that are being used, can that be challenged in any way? As I said a few minutes ago, in considering that matrix, you have to be careful that you don't inadvertently use criteria which might give rise to discrimination claims, because that is where many employers fall foul in this sort of situation. Next slide, please. I've mentioned there, can collective consultation take place when the employees are furloughed? Obviously, people have been furloughed for many months, since March in many cases. And although we're now in the flexible furlough period, it is a concern for employers as to how do the redundancy requirements impact on the furlough scheme and vice versa. We've been asked by a lot of employers whether you can undertake a redundancy consultation process even when employees are furloughed. The answer to that is that the HMRC guidance on the Corona Job Retention Scheme expressly states that an employee can be made redundant whilst on furlough. So you can begin the redundancy process, and you will have to go through the collective redundancy consultation where appropriate, and certainly through the individual redundancy consultation with each and every employee. There are, of course, some practical difficulties in relation to this situation, because when the regulations on collective consultation were drafted, of course, nobody had in mind a global pandemic and the inevitable practical difficulties that provides. There is a requirement to provide appropriate facilities, and certainly for office workers and such, it's highly likely that they'll have laptops or some other means of being able to engage in consultation remotely that might not necessarily be so for factory shop floor workers, for example. They might not have the appropriate facilities. So you may have to be inventive as to how that consultation should take place. The final point that I leave you with there is I pose the question of whether the existence of the job retention scheme and the inherent uncertainty of the pandemic mean that there cannot be a proper assessment of the potential redundancy situation. To put it another way, obviously the coronavirus job retention scheme, when it came in, was exactly that. It was intended to help with the retention of jobs and it was intended to stave off redundancies. Obviously, when we first went into lockdown, nobody knew how long this was going to last. Nobody knew when we were likely to be coming out of it. So of course, many employers were concerned. They didn't want to start consultation too soon, but equally, they didn't want to leave it too late. So you begin consultation when you are contemplating redundancies. And I think that's going to be a very interesting point, which is undoubtedly going to be tested in the courts and the tribunals in the next few months. Because if you consult too soon, you might be open to criticism. If you consult too late, you might be open to criticism. And of course, if you consult too late, then you could end up with a protective award. Right? I'll now hand you over to Andrea, who's going to talk about the other aspects.
Thank you, Chris, and good afternoon, everybody. I'm going to carry on effectively from where Chris left off. And first of all, I'm going to talk about suitable alternative employment. Now, this concept is important in the context of redundancy for two reasons. Firstly, it's, as Chris mentioned, it's an important part of establishing that you've run a fair redundancy process and that you've acted reasonably. And the second reason why it's important is that if an employer has made an offer of suitable alternative employment to a potentially redundant employee and they've unreasonably rejected that offer, then they may forfeit their right to a redundancy payment. Of course, it makes economic sense in more circumstances as well, if you have potentially redundant employees, to see whether you're able to reuse them elsewhere in the business, because that means that you don't have to pay out redundancy payments. Now, where you're making an offer of suitable alternative employment, if there is any difference between the old job and the new proposed job, which are anything more than inconsequential differences, then the employee has a right to, a statutory right to a 4-week trial period, and that trial period must start no more than 4 weeks after the old contract comes to an end. Now, if the trial period is successful, then generally everybody is happy. The employee's employment continues and they don't have the right to a redundancy payment. Problems obviously arise if it's not successful. Sometimes both the employer and the employee may agree that it just hasn't worked out, and if there's nothing else available, then the employee is redundant and is entitled to a redundancy payment. The more common difficulty is where the employer may think that the trial period has gone fine, that the job is suitable for the employee, but the employee disagrees. You may then get a dispute as to whether it was suitable alternative employment and whether it was unreasonable for the employee to reject that offer. So what then is meant by suitable? Now, this is largely an objective concept. So you look at the characteristics of the old job, things like status, terms and conditions, pay, location, and you measure that against the characteristics of the new job. However, it's not entirely objective. There is a subjective element because you have to look at whether it's suitable for the individual employee and their qualities. The concept of when it's unreasonable for the employee to turn down a job is in theory looked at separately, although in reality the two things often go hand in hand. That is more of a subjective concept. So was it reasonable for that particular employee in the particular circumstances to turn down the offer? So you might look at things like What detail were they given about the proposed alternative employment? Did they have enough time to consider it properly? Did they have a trial period? You may also look at circumstances which are unique to that employee. One example from the case law is that there was a widower who had 2 teenage children and was offered employment which was only about 5 miles further away than his old job. But the traffic in the local area meant that it would have taken him considerably longer to commute back and forth. And that gave rise to childcare difficulties in his particular circumstances. And it was held that it wasn't unreasonable for him to turn down the new job in his particular circumstances. One other important thing that needs to be remembered is that some employees, such as those on maternity, have the right and a statutory right to be given priority when allocating suitable alternative employment. So you need to look at those employees first, and it is only after you've looked at those that you can go on to look at the rest of your potentially redundant employees and whether you may have suitable alternative employment for them too. And the final point on that slide is group companies. Do you need to look for suitable alternative employment across the group of companies if your company is a member of a wider group? And the answer to that is it depends, I'm afraid. Now, in most circumstances, it will make sense if you are able to offer employment elsewhere in the group to look to your potentially redundant employees. However, occasionally there may be employees you may not necessarily wish to redeploy. And you may then get challenged that you haven't looked at the wider group. And it will depend on the relationship between the group companies, how closely they work together, whether they have a centralized HR function, for example, and also how much control the company who is making redundancies has over other companies within the group. But it's certainly something you should bear in mind. Could I have the next slide, please? Alternatives to redundancy. Now, this is something that crops up at 2 stages, really. As Chris mentioned, it's something that you need to look at the outset when you're running a fair redundancy process. It's something that you may want to discuss with the employee representatives if you're undertaking collective consultation, indeed something you're expected to discuss how you can avoid or reduce redundancies. It's also something that the individual employees may raise at the consultation stage. Now, those of you who attended our earlier webinar on restructuring the workforce will have covered this already, but to recap for everybody's benefit, the potential options are voluntary redundancy. Now, in the current economic crisis, you may think that not many people will want to take voluntary redundancy, but it's certainly worth asking, because there may be employees, for example, those who are coming to the end of their career, who might see a redundancy as an unexpected bonus and would be prepared to look at that. And there may be other employees who perhaps are already looking around for other jobs or thinking of setting up on their own, who may welcome it. Another option is early retirement. If you have a scheme where you are able to offer some kind of enhancement for early retirement, then that's something you may want to look at. It's not something that you can impose on staff because that's likely to be discriminatory and on age grounds, for example, but it's certainly something that's worth offering if you are able to. Things like hiring freezes, reducing your reliance on agency or contract staff may seem like obvious things, but remember to look across your whole business, particularly if you have a large business, that there aren't people in other parts of the business who may still be using agency or contract staff when you're making redundancies in another part of the business, and may actually be able to redeploy staff from one part to another. You may also want to look at things that reduce, like reducing hours, or looking at sabbatical, short hours, overtime bans, or even reducing pay, removing overtime or benefits. Now, those are generally all things which you will need employee consent for, and you might think employees wouldn't give consent, but when the alternative is redundancy, they might do. It's something that's worth exploring, particularly in a collective consultation scenario, where it's sometimes easier to explore these things with a whole group of employees. One point about short hours, though, is just be careful around that and perhaps get some legal advice, because that can in itself trigger a right to redundancy payment if it goes on for long enough. The final point there is about these points, if they're raised by employees during the consultation exercise, and I'm talking about individual consultation mainly here. Obviously, you do need to consider them at that stage as well, even if you have done it already. And remember to give feedback to your employees if they've already raised, these points with you. Could I have the next slide, please? Now, redundancy payments. This right arises after 2 years service. Those are 2 whole years service, and it's based on a statutory formula based on age, length of service up to a maximum of 20 years, and pay. Pay is currently capped at £538 per week. As Chris mentioned, there is new legislation that's actually coming into force tomorrow, just announced by the government today, which clarifies that if employees are currently on furlough, then you have to use their normal rate of pay for these purposes rather than their furloughed rate of pay, so that employees do not lose out because they are on furlough. Now, it's calculated by reference to age, as I mentioned, and employees get a for each full year they have worked, between the ages of 18 and 22, then they get half a week's pay. Then between the ages of 22 and 40, they get 1 week's pay. And then if they're 41 and older, they get 1.5 weeks pay. Now, this is one of the rare examples of the legislation actually discriminating favourably towards older employees, and I think the logic behind that is that employees who are older may find it more difficult to find alternative employment, and therefore should be compensated to a greater extent. For anybody who's not done this previously, there is a very good calculator on the government website, and that is by far the easiest way of working out redundancy pay. The final point there is that if you have a contractual redundancy scheme, obviously it's important not to forget that, because that may give an enhanced payment, generally more common in some sectors than others. If you are fortunate enough to have an enhanced redundancy scheme, then it's important that you look at the rules of those schemes and also any policies that accompany them, because they may give protections over and above the general law. Could I have my final slide, please? And the first point there, is there a right to an appeal? Well, there doesn't seem to be a statutory right in that the ACAS code, which is a statutory code, there, which means that employers have to follow it, apply to disciplinary and grievances and not redundancy. But it is universally accepted that it is best practice. And indeed, the ACAS guidance, which isn't statutory and is an enforceable guidance, does recommend it. And also it can be in an employer's best interest to offer an appeal, because it can be an opportunity to mop up anything that wasn't done quite as well as it might have been done during the consultation process. When looking at fairness of redundancy, you look at the fairness of the whole procedure, and if perhaps consultation was a bit lacking, if that was actually picked up on appeal and the employee was given the right to have their say and that was considered, then that can be enough to make it fair. Now finally then, if we look at potential claims, the first one there is collective consultation. If you have failed to carry out collective consultation in circumstances where the legislation tells you that you ought to have, then the employee may be entitled to a protective award, and that is an award of up to 90 days pay. Now, the week's pay for that purpose is actually uncapped, so it can be potentially quite expensive for employers. 90 days is maximum, and a tribunal will look at whether the employee should get the full 90 days or whether it should be less than that. Another important thing to remember is that you don't have to have 2 years service, something that employers can sometimes forget with regard to collective consultation. The second point there is a claim for statutory redundancy payment. So if an employee has been made redundant, but the employer doesn't pay up, then they can try and enforce that award through the employment tribunal. It can also be used, for example, where the employer thinks that they have made an offer of suitable alternative employment. The employee doesn't agree, so they can challenge that in the tribunal to try and claim their redundancy payment. The next point there is a national insurance fund. So in circumstances where an employee has been made redundant and the employer cannot pay, for example, because they're insolvent, then that is underwritten by the government, and redundancy payments do count amongst the awards that they can claim from the fund, subject to complying with the rules of the fund. The next point is unfair dismissal claims. Now, an employee could claim that the redundancy is unfair in some way, and that in fact they've been unfairly dismissed. Now, they may claim that they're not generally redundant at all, that the employer was just using that as an excuse to get rid of them, or they may claim that the selection process was unfair and they shouldn't have been selected for redundancy, or they may actually say that the procedure was unfair in some way. Unfair dismissal claims are generally capped at a maximum of 1 year's salary, and you do need 2 years continuity of service to bring an unfair dismissal claim. And the exception to that is if the employee is able to establish that the dismissal was discriminatory in some way, or was the result of them having made a protected disclosure. Those are automatically unfair dismissals, and you don't need the 2 years service. The final point there is discrimination. As I just mentioned, they can claim that the dismissal was in some way discriminatory, or alternatively, they may claim that they suffered some kind of discrimination in the course of the process itself. For example, if they suffer from a disability and appropriate reasonable adjustments weren't made for them during the course of that process. So that is all I have to say. That is my final slide.
Hopefully you all found that very interesting. I say we're very happy to answer any further questions if anybody wants to type one in. Otherwise, if we haven't answered the question, then please do get in touch. We're happy to discuss anything. The next webinar is Thursday of next week at 2:30. That will involve different colleagues, and that will be looking at managing a complex or large-scale redundancy process. So hopefully that will be useful. Thank you for attending this afternoon. We hope you've enjoyed it, and hopefully you can enjoy the rest of your afternoon. So thank you all very much.
Thank you.